Yes, Vicharism.
My please, Lordship, may I pray, my Lord, to allow me to move on this motion tomorrow. I'll be filing it in the course of
Regarding
the closing of the shop. Last day before his Lordship has taken up one matter, insisting to obtain the NOC from the Milan same ship. Similar, same building, my Lord, District Council issued a close order to all of them. I'm filing
tomorrow is court setting only for an hour and a half, I think.
But we are filing after some time only, my Lordship. I look at you.
May I please, Your Lordship? I beg to mention item number 47, Lordship. Due to personal difficulties, let this matter be spoken after 1 week, Lordship.
You have objection?
No objection.
Let it be after 3 weeks, my lord. There is no urgency in this matter. This is not my matter, my lord.
Yes, Lordship.
No urgency. It's a 22 matter, 2 weeks, yes. It's 23, you'll give 3 weeks. Yes, 22, 2 weeks. 21, 1 week. Yes. Yes.
Similar purpose, item number 51, Lordship.
51?
Yes, Lordship.
You have objection here?
No objection, Your Lordship. I'm for the petition, Your Lordship.
Any urgency? 2 weeks, okay.
Highly blessed, Lordship.
One matter I want to mention is regarding that contempt matter 36, serial number 36 of the hearing list. My lord, this is that matter where it was partially heard, where I have come before this honorable court where my son was alleged to be hanged himself, my lord. Yeah.
D. Basu?
Yes, D.K. Basu, my lord. Now, my lord, division bench has passed an order. So I have contacted the client, but she is suffering from viral fever. I just want to explain her what is the order of the division bench and whether she wants to pursue this matter or not. Let it come after 4 weeks, my lord, this matter.
Okay. 4 weeks enable the counsel for the petitioner to obtain instructions, yes.
Hello.
Yes.
May it please, Your Lordship. Lordship, I beg to mention item number 48 and 49. The conducting counsel B. Pathak is out of station.
He's in Guwahati?
No, Lordship. He is in New Delhi.
Okay. 2 weeks.
Oh, please, Lordship.
No objection? No. Yes, from Thao, okay. Yes.
Please, Lordship, I beg to make a mention item 44.
Who's for the side? I'm for the other side. How long? 2 weeks.
2 weeks.
Okay. No objection. Yes, that's it.
Your Lordship, I beg to mention item number 39, Your Lordship.
On behalf of?
Yes, Your Honor. Your Lordship.
On behalf of?
I beg to
Respondent
mention-
or petitioner? Or appellant?
So he's not here, Your Honor.
You're for the appellant or for the
I'm for
respondent?
the respondent, Your Honor. Your Lordship.
From Mr. Mansoori?
Yes, Your Lordship.
What happened?
He's not, he have personal reasons, Your Lordship.
Have you informed the other side?
I'll inform you. I've been searching for him, but then he's
You
not.
kindly inform them.
Yes, Your Lordship. 2 weeks may be given, Your Lordship.
Mr. S.R. Lingdo, I think it's the other side, yes.
Supplementary list, item number 1.
Yes. At the end of the board, at the end of the board.
You ask for urgency, we are top of the board. Otherwise, otherwise then we'll take it to Monday. You mentioned, this is a word mention. There's no question of adjournment.
At the Lordship, seniors engage in the court number
You are
1.
there? What is the problem?
Lordship, I'll have some. You'll be in a better position. Lordship.
Monday?
No, Lordship. At the end of the board. Lordship.
End of the board.
Item number 2.
May I please, Your Lordship?
Yes.
Conducting counsel is engaging in another court after some time, Lordship.
Number, come to take it.
My lord, in this matter,
Yes.
Mr. Sama has filed a miscase to transfer the title suit.
Yes.
Now, my lord, in a miscase, can the matter be transferred without hearing the other side? I'm not for the private party, my lord.
Yeah.
But notice has to go, my lord, in this case also.
Who was appearing on the other side?
We are just to assist this honorable court as per the order of this honorable court, my lord. But private respondent, they have not even appeared, my lord, in the main case also.
They didn't appear in the main case. Were they main parties?
They are the party, my lord. It appears they are the party. Let notice go, my lord, for the miscase.
Junu Sangma.
Yes, my lord.
Let notice go, yes, better. Miscase number 15/2023 in miscase of CRP 11/2023.
This is
Miscases. This application has been filed seeking transfer of title suit number 8, which is pending in the court of Srimati P.S. Marak, Assistant Judge, District Council Court, to the court Additional Judge, District Council Court. Stop. Issue notice to the sole respondent. Steps to be taken within 3 days. List after 2 weeks.
Main list item number 1.
Yes. Any instructions?
Your Lordship, the petitioner, Your Lordship, she was appointed on ad hoc basis. And due to oversight, Your Lordship, her name was not recommended when the cabinet had done the regularization on 15/3/2022. So now, Your Lordship, the department is in the process, Your Lordship, of regularizing the petitioner.
You've come for what?
Retirement benefit, yes, my lord.
Pension.
She has
Then you don't
retired.
regularize. How do you get pension?
My lord, she has, my lord, may kindly see the annexes, my lord, there. She has retired, she has worked for the whole life, my lord, and then,
You work for the whole life, fine. But then if the process is not in order, how you work for the whole life and
my lord has similar issues, my lord has already decided in other cases, my lord.
how many years you worked? When did she join? When she was appointed? Where's the order of appointment?
Annexure 1, my lord, does not say, my lord, it just says that she is returning from 30th April 2023.
Don't you know how long she's worked? She doesn't know herself also.
My lord, I need some confirmation if necessary. My lord,
Your
let them
Lordship,
file
as
one
per my
affidavit. my lord.
instructions from 1990, Your Lordship, she was, she had to work against leave vacancy, Your Lordship. Then since
You
there
come with
was,
instruction to file an affidavit.
yes, Your Lordship.
Yes, Ms. Ailingwa prays for allowed 2 weeks time to file an affidavit. As it has been submitted that the pension, the pension other entitlements have not been released due to the fact that he is an ad hoc employee who is yet to be regularized. Who is yet to be regularized, yes, by the respondents. Just up to 2 weeks, yes. You file an affidavit. Then we dispose of next day.
Item number 2.
Mr. Bora was to take steps, my lord, on the answer.
He hasn't even taken steps to present himself for the court. Officer Amman. None appears for the petitioner just after 1 week. He needs to obtain a correct address.
Item number 3.
This is contempt, lordship, non-compliance of the order.
Your Lordship, as per my instructions, Your Lordship, the service book of the petitioner is being reconstructed, Your Lordship, and it has been forwarded to
What order was, what does the order say? Within how long?
6 weeks, lordship.
It's been forwarded, Your Lordship, to the Director of Local Funds for approval. Once it has been approved, Your Lordship, it will be released, Your Lordship. DCRG and all the benefits.
Only for DCRG.
Yes, Your
DCRG.
Lordship.
Then let it be listed after 3 weeks, lordship.
Yes, MS Ailingwa, the council response submits that there is no willful violation inasmuch as the service book of the petitioner has to be reconstructed to compute the DCRG amount. So I'm disagreeing with the matter. This is a matter for 3 weeks. So wait further instructions. Yes.
Obliged, Lordship.
Item number 4.
4 to 14?
May it please your lordship. Lordship, in this matter, item 4 to 14, your lordship, we are praying for some more time, your lordship.
For what?
Filing affidavit, your
What's the
lordship.
matter about?
It's about regularization, Your Lordship. Your Lordship, it's almost 5 months now, Your Lordship.
10 days only, your lordship, we'll file it.
All the cases are similarly situated.
Yes,
All of
Your
them.
Lordship.
Lordship, yes.
Though this writ application has been filed since the month of April 2023, affidavits are yet to be filed by the state respondents. Stop. Next paragraph. Mr. N.D. Shulai, then AG so-and-so, has today again made a prayer for further time stamp. For a time stamp. According to the interest of justice, further 3 weeks' time is granted. It is expected that the affidavit should be on board before the next day.
Highly obliged, your lordship.
File it, otherwise.
We'll file it, your lordship. We didn't but we'll file it.
Item 15.
Yes, Mr. Sheikh.
Final hearing, Lordship. Final hearing.
Reading is complete. You want for the agenda? Mr. Council of Vice submit that reading is complete. All this is matter for hearing and so on. So
16.
Your Lordship, first of all, I tender my apology because on the last stage, Your Lordship, we had said that we would be filing the affidavit in course of the day because we had already sent the affidavit to the department for the signature. But then we received a letter saying that they would like to reconsider the whole matter again because the file is lying with the personnel department. So we pray for some time, Your Lordship, in this matter.
MS T. Yangi, B. Leonard AG with so and so submits that though on 1 September 2023, submissions had been made that the affidavit would be filed in the course of the day. The same was not done due to the reason that additional instructions were received. Matter will be settled. I mean,
they are saying that they are re-examining the matter in consultation with the personnel department.
Submissions had been made. We received that the matter was being re-examined by the state respondents. A copy of the letter dated 4th September 2023 indicating this fact has been produced for the court. So, considering the submissions and the reasons aforesaid and considering the submissions and the aforesaid reasons, state respondent granted how much time? 3 weeks for the time to file the affidavit. This thereafter and so on. I know. Take back the letter.
17.
May it please your lordship. We filed the affidavit, your lordship.
Apply for 3 weeks' time, your lordship, to file rejoinder. To file rejoinder.
3 weeks' time is too long.
2 weeks.
Still too long. Okay, you didn't appear last time. None appeared on the last date, yes. Mr. D.K. Datta prays allowed 2 weeks time to file a joint rapid file by the respondents. Prayers allowed this up to 2 weeks.
Obliged.
Item 18.
Please, Your Lordship. May I please, Your Lordship? Your Lordship, if I may be allowed to withdraw the writ petition, Your Lordship, with a liberty to file fresh.
Why?
Some defective is there, Your Lordship.
Yeah, Ms. Ipajo.
Your Lordship, I am for the respondent number 3.
Do you have any objection?
3 and 4.
You have objection?
My lord.
Yes, no objection.
Yes,
Yes.
if you want to.
MS Ipajo, the constable petitioner, prays that may be allowed to withdraw the petition with liberty to file a fresh issue whenever is stopped. Mr. S. Sheikh, you have 1 and 2?
3 and 4.
Or 3, 4. No, 1 and 2. Have no objection. Stop. No objection. Stop. Accordingly, the matter stands closed or withdrawn. However, liberty as prayed is.
19.
Please, Your Lordship. Lordship is supposed to file the affidavit. We'll be filing it in course of the day.
Lordship, in this case, just for disposal only, just for directions. Because if they file an affidavit, they have taken 2 grounds. There is some other person also filed a proposal. We just want the director to take a decision.
That affidavit comes in, they'll fill it and file it. We'll take it up next week. Mr. E.R. Khan submits that the affidavit will be filed because of the this matter. On next week is
Monday.
Now it's 21st, correct? This 27th.
Highly obliged.
Item 20.
May it please Your Lordship, I'm praying for 3 weeks' time, Your Lordship, to file an affidavit, since it's a new matter.
MS and Sunflower prays for not further 3 weeks time to file affidavit listed afterwards also.
21.
Any long series, eh?
21 Your Lordship, I appear for
9 to 13, yes. Inquiry is complete, Mr. Shulai.
Lordship, if Lordship is pleased to order dated 24/8/2023.
Yes.
Respondent, Your Lordship, minus
8/40/15 file 5 sales report.
Yes.
Who's 5 to 8?
They are the Union of India as well as the.
That is S from Thao. Where's the report?
The information just now I received from the ministry that inquiry report has been submitted by BSF.
Where? To whom?
To the ministry, and it is under the examination of the ministry.
By order dated 24/8/2023, the respondents 5 to 8, 14/15 represented by Dr. N. Mozika, Leonard DSG, who was supposed to file a status report with regard to the progress of inquiry. Stop. Today he has apprised the court that the inquiry has been completed and the report has been sent to the ministry for confirmation.
It is under consideration.
For consideration, stop. In this view, the matter we listed after
4 weeks, Your Lordship. That will be 4 weeks.
Missed after 3
4
weeks.
weeks.
Yes.
Lordship,
For the orders.
item 21 to 31, then 33, 34, and 35.
Just give the list. Inquiry is very voluminous or is perfunctory?
I haven't seen it.
Yeah.
Item
I'll get the
32.
proposal.
32.
Oblige, Your Lordship.
duty of life.
Mr. Sheikh, you're not here on the case.
I am for
32.
32 is called.
32 is appeal 32. Is series of matters on also? Series. Because 32 Mr. Sheikh last time appeared. You don't know your own cases anymore. You have too many. Then you farm it out to other juniors also.
May I please your lordship, this case is conducted by Mr. Abraham and
So, what can the court do?
may I just praying for time, your lordship. Your lordship, may please to allow certain time because he's on his leg in the other court.
Lordship, because this is
The pay has been stopped. What instruction?
Yes, lordship. Home guards, volunteers, lordship.
Short date may be given, your lordship.
So
time.
from July.
Yes, lordship.
He was supposed to obtain specific instructions on the
Yes,
on the
lordship.
terms of engagement and entitlement of the writ petitioners.
Suddenly,
Where is he?
he's on his leg before rather court number. He's before before court
On
number
his
three.
legs.
On his
Not
legs.
not on his leg, yes. Which court?
Court number 3, your lordship.
We'll take it up sometime. Suppose come specific instructions.
I'll inform you, your lordship.
You inform him.
Hearing supplementary list, item number 3.
Why was it fixed for printers today, this matter?
Lordship, in fact, on that day, it came at the last end of the first half, Your Lordship. That's why we pray that if it is possible to take up the matter.
Yes. What's the matter about?
Your Lordship, this is already heard, part is a part heard matter.
No, what is the matter about?
Lordship, I have been doing the salary for more than 20 years with the increment, the 2 increment and the promotion. And Your Lordship, now the Queen's order is that I was asked to recover. So in that
I don't understand. He asked to get the time
to recover.
You have been
receiving the salary and the increment for more than 20 years. Then one fine day, I was asked to recover the amount.
The respondent want to recover the amount from you?
Yes.
Why? On what ground?
Because it is an wrong payment to the by acting on the draft rules. By acting on the draft rules, and they have given the 2 increments and the promotion, and then now they want to again want to take it to recover that amount which was
how much amount?
That they have to the respondents to calculate, Your Lordship.
What's the matter?
This is Your Lordship. Your Lordship, my friend with your
motion. Motion pass 1 minute. End of the board, end of the orders. We just hold a matter. There's the other motion matters there, end of the board, where Mr. Nongpir had taken time.
Second call, supplementary list, item number 1.
Sorry, Your Lordship.
No, it's all right. There's nothing for you to be sorry about. It's for us to be sorry. At the end of the board is after the orders.
Apply, Your Lordship.
Kami lay them done offered by them. Then it's not too bad. What is this?
Now we have to come back again, my lord. My lord, the earlier round Your Lordship is disposed of by order dated 4/9/23, my lord. That is at page 296, my lord. 296.
296?
296, my lord. Page.
Yes.
Para 8, my lord. Para 8 at page 300. The direction was, my lord, this court is not inclined to issue any interim orders for the suspension of the tender process at this stage, but however the petitioner is allowed to prefer a representation on the grievances as made out in the writ petition before the respondents before the opening of bids, which has been scheduled on 8/9/2023. Such representation shall be preferred by 6/9/23, which shall be disposed of by the respondents positively by 7/9/23, my lord.
What happened?
There was a positive direction, my lord. So, my lord, we were given time till 6th September, my lord. We submitted the representation on 4th itself, my lord. On 4th itself, when the order was passed by Your Lordship, my lord. Now, what they did, my lord, Because there were 5 major areas of grievance in the earlier round of writ petition, my lord. Number 1 was that the schedule which they adopted was not in conformity with the amended law, my lord.
That is foregone. They are taking that. I remember Advocate General said it will be in.
My lord. So, my lord, out of 5 grounds, my lord, 3 grounds were in deviation with the statute itself, my lord. So now what they did, my lord, after we submitted a representation, 3 of the issues they have addressed, my lord, which were in direct violation of the statute itself, my lord. But our grievance, my lord, which concerns us directly, my lord, number 1, that experience is required for last 3 years, but they have defined this as 19, 20, 21 and 22, my lord, whereas 31st March 23 has already gone, my lord. Now there was a direction by Lordship to dispose of the representation by, though not spelled out, my lord, by speaking order, my lord. At least we know Lordship also have the privilege that what is the reason that 22, 23 has not been included in the NIT, my lord. My lord, may I take your Lordship to the corrigendum, my lord?
What corrigendum?
They issued a corrigendum that is at page 313.
313.
313. After our representation, my lord, they issued this corrigendum.
Page 6.
My lord. Page 313. My lord.
Okay.
My lord, they have extended the date till 25th of September now. Today is 21st, my lord.
They extended to
25th.
A bid submission
on the same date.
8.
Submission also on the same date and opening also on the same date, my lord, 25th of September.
Okay.
Now, my lord, by this they have made several changes, my lord, and more importantly, they adopted the schedule at page 320, my lord, Lordships can see. $320. So they have adopted the new schedule, my lord, as per the amended food.
No quarrel with that.
No quarrel with that. Now we have quarrel only on 2 issues, my lord, because the original provision in EOI at page 89, my lord. Sorry, my lord, page 87, my lord.
Yes.
Page 87, clause 6, my lord.
Yes.
The documents relating to past experience of supply of micronutrient fortified dense food to Social Welfare Department of rupees 10 crore each in the last 3 years. Now, last 3 years they say, my lord, but then
I remember now. Yes, he said that he wanted to be 23, but he said that 23 won't be feasible because account closing is October 31st.
My lord,
you have to get the accounts for 23.
My lord, kindly see, my lord, in bracket in the same clause, my lord, order copy.
Yes.
And work completion certificate to be enclosed.
Yes.
What is required is only order copy, my lord.
Yes.
In my humble submission, this is an arbitrary clause, my lord. When it says last 3 years, my lord, last 3 years, 22, 23 lapsed on 31st of March itself, my lord. We are in the month of September, towards the end of September, my lord. 6 months is gone, my lord. There is no reason, my lord, in my humble submission, and putting this 3 years, specifying this particular 3 years, my lord, in my humble submission is absolutely arbitrary, my lord.
They don't have that latitude to do it.
In my humble
since they're the owners of the project.
My lord, what I can submit, my lord, 3 years, March has gone by, my lord. 6 months over, my
Dr.
lord.
Mozika, how unreasonable is it that it will warrant interference of the court? You're asking for 3 years of, like, from 2019 to 22.
My lord, they said last 3 years, my lord, in the same very clause, my lord. Then bracket 1920, 2021, 21, 22.
Because if the last 3 years you don't include 23, that means you will not be eligible. I mean, that is your grievance.
My lord.
That is the only thing. Because if 20 is included, you'd be eligible.
I am eligible, my lord.
Okay. So you have a welfare, yes. Next.
That is first submission, my lord. My second submission, my lord, is again, my lord, Clause 6 indicates, my lord, that the eligibility requirement, the basic eligibility requirement is turnover of 10 crore only, my lord, in last 3 years. My lord, I have turnover of 400 crore rupees, my lord. So that is absolutely no issue, my lord, about the turnover. Problem is, my lord, with the page 101, my lord.
$101,
101, my lord.
85 points.
85 points, my lord. My lord, Lordship will see at serial number 5, my lord.
This is your next point.
This
only
is
2 points.
Only 2 points are left now, my lord.
I want you to raise them before.
I raised, Your Lordship did not enter into the merit of the contentions, my lord. Your Lordship have directed them to dispose of our representation. They have not disposed of any representation, my lord, till date by any speaking order. At least the dispose of, we know what is the ground or on what basis they are not accepting our contention.
You answer these questions, by tomorrow. If this have been put up, the earlier petition.
These are the 2 issues. Yes, Your Lordship is right.
The demands answer. It can be positive or negative, doesn't matter. But then at least you have the clarification that it doesn't matter.
Yes,
we are the owners of the work.
Yes,
we will prescribe 91, 92. Who are you to say?
Yes, sir.
If that is the thing.
At least we know what is the wisdom behind putting these 3 years, my lord.
I understand.
You come with instructions tomorrow morning. Heard with Dr. N. Modika, Leonard,
Yes, Your Lordship.
Senior Counsel.
In fact, my lord, yes, Your Lordship, if I may submit, my lord.
Yes.
What has happened that we will dispose of the client of Mr. Dr. Modika, file the representation, my lord. If I so want to, probably the issue will get resolved, my lord. Can you see what my friend has placed before Your Lordship is the email through which the representation was submitted at 301, Your Lordship will see at page 301. 301.
Okay. Yes.
And the one representation, my lord, and 312. Your Lordship, can you see 312?
Yes. Yes.
Respected sir, please find attached representation of Mr. Kota Dalgil as per direction of Honorable High Court dated so and so. Then at the foot of the page, my lord,
Yes.
the reply reference the online bid for procurement of ready micronutrient fortified energy food same has been extended up to 8 September and has been published in court and has been published corrigendum online. Any other corrigendum issued by department may be viewed in Meghalaya Tender. You are requested to check the portal from time to time. And then thereafter on 14 September on which page they have issued the corrigendum. But these 2 issues should have been addressed. Kindly give me time till Friday. We will pass the order on these 2 issues also. Because this should have been, we will pass the order. We will pass the order on the.
At least they demand answer whether it's right, whether it's left or right, or positive or negative. Yes.
The second point, if I may elaborate, is a little bit, my lord, for the benefit of.
Friday we will pass the order. Tomorrow we will pass
Let them pass order.
on Monday, Lord, so that we can.
Yes, I heard Dr. N. Muzika, Senior Counsel, on behalf of the petitioner, assisted by so and so. Stop. Mr. E. Kumar, the Advocate General, is present with Mr. Silpan and so and so for the respondents. So the notice is complete. Stop. It has been submitted that Dr. M. Muzika submits that this is the second round of litigation with regard to an EOI dated
18/8/2023.
18/8/2023. Stop. Attention of the court has been drawn to the order passed in, where is that? WPC number
298/23.
298 of 2023 in earlier regulation. Yes. Attention of the court has been drawn to the order dated
4/9/23.
4/9/23 passed in WPC
298/23
in earlier litigation, wherein the petitioners were permitted to prefer representation on the grievances as made on writ petition. And the respondents to reply to the same. Stop. Today, it is submitted that the second writ petition has been filed in view of the fact that on 2 issues, that is on the relevant years to be taken into consideration and also for the calculation of points of eligibility. No? In view of and the calculation of points of eligibility, which is contended has been answered by the respondents. Next by Mr. A. Kumar, Advocate General, submits that if this is the case, the respondents will look into the matter and answer the same accordingly. He prays for accordingly by tomorrow's 22nd, by 22nd September.
Well, only difficulty was the tender last date and opening is on Monday itself.
Yeah, list the matter tomorrow.
My friend has 18 final only.
Yes, list the matter tomorrow for further orders and for instructions from the respondent.
We have to pass the order. We will pass the order by tomorrow. It will take some time. So by tomorrow evening, we will pass the order. Make it on Monday.
Monday is the bid opening.
Last date of tender submission.
25th is the last day tender submission and bid opening same day.
My friend, if I say my friend has not even submitted the tender, what I can say, he has not participated in the tender.
You still have time to
tender till 25. Tender may be tender condition so that I become eligible.
You answer resignation. You answer by tomorrow morning. Mr. Advocate General, it's only 11 o'clock. You by tomorrow morning, the order should the instructions should be on board. We'll pass because this at 10 will this is tomorrow. Yes.
Hearing supplementary list.
Yes, where's Mr. Shati? Yes.
May I please, Your Lordship? I had joined the.
You're working as what?
As
you start from there. You working as?
Forester.
Forester.
Oh, sorry. As a forest guard. Yes. Working as a forest guard from the year 1990.
Are you prepared with the matter?
Yes, Your Lordship.
Are you fully prepared?
Yes, Your Lordship. In the year 1999, I was working as the.
In the year?
99.
99. Let us see a repetition. Yes.
Then in the year 2001, Your Lordship, I had appeared for the training where I have secure the honors certificate and in the on the which was under the draft rules of Forest Guard School of Meghalaya Training Rules to 1994. Then thereunder I have qualified and I secure the first. I secure first, and so according to the rules, I am entitled for double increment and plus with the promotion. So Your Lordship, after I received the increment was started in the 1st of August 2001. From there the increment had started, and Your Lordship, I had received a promotion only from in the year 2012. Then after I received the promotion, then after that I didn't receive the MACP. Then now from 2012 till now, so I'm due in 2022 to get the promotion or to get the MACP. On that at that time, I in fact received the impinge order. It is at page 69. Yeah. May I allow to read, Your Lordship?
22.
Yes. 12.
Why is this letter impugned?
Your Lordship, here.
Cancelling the advance increment.
Yes, Your Lordship.
Yes. Yes.
Yes. In that regards, I have come before this honorable court to set aside this order.
What's the reason they give for cancelling it?
Cancellation is that I was wrongly, the increment was wrongly given in the draft rules. So that is the
wrongly given draft rules. That means that the department is following the draft rules.
Yes, following the draft rules.
And they give you advance increments because as per the draft rules.
Yes, Your Lordship.
So after they turned back and said that no, we can't give you increments.
Yes, Your Lordship.
So they cancel them.
Yes. They want to cancel.
What about MACP, you're saying?
MACP, because now I'm due for the MACP. So since the promotion is or the retirement is already due by this year, by October or November. On that basis, Your Lordship, since I'm entitled for the MACP, so they want to adjust that increment with the MACP.
MACP, you won't get a progression, only upgradation of pay. You'll be getting.
Yes.
For MACP, what is it? What is it, Mr. Shulai?
May it please Your Lordship. Your Lordship, what happened? He's a forest guard. He was promoted only in the year 2012.
Okay.
Prior to that, Your Lordship, in 2001, if Lordship kindly come to page 45 of the writ petition. He was granted this increment, Your Lordship. In the year, then what happened, Your Lordship? In the year 2022, the government.
Okay, just come back to this 2001, 31/10/2001, right? Where you see what a draft service was nothing. Just says that dated so and so on company of 7 batch forest guards training at so and so have been awarded an honor certificate to advance payments of ₹50 is granted to.
Then Lordship kindly come to annexure 17 at page 69. So, Your Lordship, the government realizing that that was a mistake, Your Lordship, because.
Well, where's the mistake here?
Lordship, I'll point out that. Lordship, kindly come to page 69.
Yes.
Lordship, page 69, if Lordship permits me to read.
Yes.
In modification of this office, no, so and so, and as per government number dated so 16/9/2002 and so 19/3/20. Advance increment was already granted to Shri. That means the petitioner raising is hereby cancelled. Your Lordship, what is that letter dated 16/9/2002? That Lordship will find it at page 47, Annex 6. If Lordship permits me, I'll read it. This is issued in 2000 by the Undersecretary Finance Prohibition to the Conservator of Forest. With reference to your letter, I am directed to say that the benefit of one advance increment admissible to Forester Grade 1 on successful completion of training in Forest School as inquired in the MSR 19 is deemed to be still in operation as the government has allowed the system of advance increment to continue with the 1979, 1987 and 1996 prohibition subject to the existing term and condition. No separate government order are necessary for the withdrawal of these. Under the existing rule, order advance increment are allowed to government employees for posting higher and or specialized quality than the prescribed minimum for appointment to the post under various department of government. A Forester Grade 1 who has passed the departmental training is deemed to have obtained a special qualification and therefore qualify for grant of one advance increment. So, Your Lordship, that is why I said if the government realized the mistake, Your Lordship, because Your Lordship at the time when that increment was given to him, Your Lordship, he was not a forester. He was only a forest guard. So a forest guard, he was not, as a forest guard, he was not entitled to this increment, Your Lordship.
Okay. Then?
Lordship, kindly come to page 65, Your Lordship.
So you're saying that only for forest guard, not forester?
Yes, Your Lordship. Lordship, only the forester is entitled to that increment, Your Lordship.
Not forest guard?
Yes, the petitioner being, the admitted fact is that, Your Lordship, the petitioner, he was promoted.
Down, say your thing. You can reply.
The petitioner was promoted as forester, Your Lordship, to the post of forester only on 16/5/2012. But his increment, Your Lordship, increment was given in 2001, Your Lordship. Which he was.
So are you planning to say that you're balancing out MACP with the advance
no, Your Lordship,
already got?
So far that MACP, I'm coming a letter, Your Lordship. So because of this, Your Lordship, for the time being, if Lordship is pleased to kindly come to page 65.
Yes.
This is the letter issued by the Divisional Forest Officer, Your Lordship.
Yes.
Lordship will permit me to read. With reference to the letter on the on the subject cited above, I am to inform that the Forest Guard School of Meghalaya is yet to be formally approved and notified by the government as it appears, and therefore is still in the draft form. It is, however, considered as a guiding principle for smooth running and conduct of basic training of the frontline staff, namely forester, Forest Guard, and Malays. In this connection, pending notification of the training rules, one advance increment can be granted only to the forester who have successfully completed the basic training in pursuant of the government instruction dated 16/9/2002, the one which I had referred earlier, Your Lordship. So, Lordship, then government notification, Your Lordship, speak only the entitlement of the increment, Your Lordship, is applicable only to the forester.
So you say that now only after promotion to Forester Grade 1 he'll get that.
Yes, Your Lordship. Then
why did you grant it to him in the first place?
Lordship, it was wrong. It
What
was
the law
detected.
governing that?
It was detected.
How do you recover it from him?
No, there is no question of recovery, Your Lordship.
He said it's going to be
No,
recovered.
that Lordship, since my friend was making the argument, I was about to interrupt him, so it's not wise on my part, Your Lordship. That submission, with due respect to my friend, is wrong. It's wrong, Your Lordship. It's wrong. Yes. There is no question of recovery, Your Lordship, because Lordship kindly come to the impugn letter. The impugn letter again at page 69, Your Lordship.
Yes.
It's only it's a cancellation simpliciter, Your Lordship. It's not a recovery, Your Lordship.
Here, Shati.
So, Your Lordship,
if that is the situation, that the advance increments given to you due to a wrong interpretation or You know,
that is, Your Lordship.
The forest guard is forest guard.
We are not going to recover.
And he only promoted 1,000
because it was a mistake
coming
on
to
our
MECP now, is he entitled to one upgradation or promotion since completed 10 years as a forester?
Yes.
Are you balancing that out with?
Then Lordship kindly come, if Lordship kindly have the affidavit filed by the state so far that MECP is concerned. Lordship kindly come to para 13 at page 4 of the affidavit.
See, no question of recovery, Mr. Shati.
No, Lordship. Lordship will.
Then maybe will interfere. Yes.
Lordship, page 4, paragraph 13, Your Lordship. May I read it, Your Lordship?
Yes.
That with regard to the amendment made in at paragraph 13 of the writ petition, answering dependent state that the process for counting MACPS in respect to has not been completed as the advance increment granted to him into has to be regularized first as per the order dated. So
that's what this court is saying.
Yes.
That you're planning to balance out the
Yes,
MECP.
Your Lordship,
That means you won't be given to MECP.
Yes, Your Lordship. We'll keep.
Yes.
We will keep.
Where's the
Lordship. We'll have to do the.
Your name's not here. What's your name?
Boniface.
But it's not here in this letter, Mr. Chulai.
Lordship, kindly see the second paragraph, Your Lordship.
No, see this. With reference to your letter, so-and-so directed return with unapproved initial pay statements of the following employees.
No, Your Lordship, because these people, 1, 2, 3, 4, they have asked for increment, Your Lordship, increment. So that is why it has been turned down, Your Lordship. Kindly see the second paragraph, Your Lordship. The admissibility of advanced increment for passing training as explained in our letter dated so-and-so relate only to forester. The forester, in the case of forest guard, grant of should have prior approval of the government. As the question of advance to the forest guard is still under exemption of the government, the benefit is not admissible to them respectively in anticipation of approval thereto, Your Lordship. Even that increment, Your Lordship, was wrongly given to the petitioner also. That also had been done without the approval, prior approval of the government, Your Lordship. The name which has reflected, Your Lordship, in that letter, Your Lordship, this is the name of the forest guard, Your Lordship. That is why it has been replied, no, they are not entitled here.
Any authorities?
Your
Have
Lordship.
you disposed it off, huh?
Lordship, so my humble and respectful submission, Your Lordship, it is within the permissible power of the government, Your Lordship. If the mistake is detected, Lordship, it can be rectified.
No, there's no question of recovery, then it's all right. But the thing is that because submission by Mr. Shati was that they're trying to recover.
No recovery, Your Lordship.
Oh, you say you have to recover?
No, Your Lordship.
No, Your Lordship.
You recover from the client.
No.
Agreements, yes.
Your Lordship, see if modification is made, Your Lordship, in this regards. If modification is made in this regard, as my learned senior have stated. So
modification meaning?
Modification on the order. So suppose if I am to get 58 as the last payment for me before I go for retirement. So if in that case, then I am no more to get that 58, but I'll be getting like 57 or 56. So in that case, Your Lordship, it will affect my retirement.
Oh, you mean the pensionary? How to calculate a pension?
Yes. So on that basis, also, Your Lordship, it amounts to like deducting my salary. So
what is the scale that you're drawing now?
Scale.
It'll be in your last pay. They'll compute your pension. What's the pay scale you're drawing now?
Now the basic is 35,700. Then the gross total that I'm getting is 51,480. So that will affect my pension, Your Lordship. So I have the decision also.
Yes, let's see that.
In the case of in Gujarat, in High Court of Gujarat and others versus Gujarat, Kishan Mazdoor Parashat is
Now let's have the judgment first.
2003 4 SCC 712. I'll take only the relevant portion.
Yes.
Para 27. May I read, Your Lordship?
I'm sorry, let me see what is the.
Para 27.
Once again. On draft rules.
Yes, Your Lordship.
Now, even then, as per the draft rules, are you entitled to the advance increments?
Yes, Your Lordship.
As per draft rules?
Yes, Your Lordship, because I have passed the training. If we go to page 40, Your Lordship.
40,
Page
40.
Yes, 40 of
yes, let's see.
repetition. B Khadanga.
1 second. Page 40. This page 40 is name of trainees.
Yes, Your Lordship. I am secure stood first position among the forest guard.
Not forest guard.
Forest guard.
No, where you want to show the draft rules?
Oh, draft rules. Is at page 26. Page 26. Para 3.
It just says that para 3.
Yes.
No, but is this rule been implemented?
No, Your Lordship.
This is a draft.
But it's the intention of this government to implement these rules.
No, Your Lordship. That's why that has been reflected, Your Lordship, in the letter.
Now you got honor certificate also.
Yes, Your Lordship.
Candidates carrying honor certificates will be granted 2 additional increments, and those carrying pass certificates will be granted 1 additional increment immediately after passing training. The increment in this case will be given. Where does it say forest guard? Where, Mr. Shati? There's not forester or forest guard?
Your Lordship, because at that time when they called for the training, they have not mentioned any whether we are a forest guard or forester 1 or forester 2. But we had attend for the training, and after we completion of the training, Your Lordship, they have awarded me the first position since I am doing my best and securing 75 marks of percentage.
No, it doesn't matter, but does it say forest guard or forester? Where does it say? In the draft rules? Yeah, this is what are the rules called?
The
Forest Guard School of Meghalaya.
School of
Yes.
School Training Rules
Training rules
1994. Yes. So according to this training, Your Lordship.
Yes, your submission is correct. If he was a forest guard and if the
Your
draft
Lordship, that has
rules
been-
being followed, that means he stood first. You got Forest Minister's Prize also.
That has been.
You got the prize, Forest Minister's Prize also.
Yes, Your Lordship.
You got it. Then what is this?
Lordship, that has been clarified by the letter dated 16/9/2002, Your Lordship.
Then why do you follow draft rules then?
Lordship, we are not following the
Then why
draft.
do you give Forest Minister's Prize?
No, Your Lordship, that was the mistake. I made a submission, Your Lordship. It was a mistake, Your Lordship. It was a mistake of the part of the government, of the part of the department, Your Lordship. Because that is why the government has issued the letter dated 16/9/2002, Your Lordship. Kindly come again, Your Lordship, to that letter dated 16/9/2002 at page 47.
Now you're drawing what P? You're drawing this, you go to annexation 9 of your petition. 2012. That's
Yes.
2012. 21st June you promoted, right?
Yes.
And where's the MACP? Where's the MACP documentation after 10 years? Where is the way you annexed it? That after 10 years you're entitled to assured career progression. Where is that?
After 10 years.
It's after 10 years. You said after 10 years you're entitled to MACP. Means
Yes.
assured career progression. Correct?
Yes.
If you're not promoted, maybe it'll upgrade your.
Yes. Yes.
So yes. Now where's the document? You should to show that you're, that this is the scheme.
Your
This
Lordship
one,
is at
page 56.
56.
Yeah, where does it say?
Page 60, Your Lordship, and
Yes.
para 18.
Page 60. Page
60, para 18. May I read, Your Lordship?
Yes.
Placement under the scheme shall be.
See, one thing, if an employee already got one regular promotion before who is joined service, he shall be known 20 years. Then you joined service in the year?
1998, Your Lordship.
1998.
Yes.
1998.
Yes.
You got a promotion 2012.
Yes, Your Lordship.
Okay.
Got promotion 2012.
Yes. But it's only after 14 years.
Yes, Your Lordship, but I have received one increment, one MACP before I get my promotion in 2012.
No, where you say entitled to after 10 years, just from this memorandum. You say that 18, reading 18, correct? You're reading clause 18, correct, of the
Yes,
memorandum.
18, yes.
The placement of the scheme shall be counted against regular promotions availed from the grade which employee is appointed as a direct recruit.
Yes.
Your direct recruit is forest guard.
Yes, Your Lordship.
If the first placement on the scheme followed by regular promotion, the second placement shall be admissible to employee, but shall they bar him or third placement but he completes 30 years of service. So you recruit 1998, correct?
Yes, Your Lordship.
Then you were given the first regular promotion 2012.
Yes, Your Lordship.
So are you entitled to MSCP now?
Your Lordship, as after I got promotion as Forester 1, so now now in 2022 I'm entitled again for the MSCP since I have no more chance to go for promotion after 10 years.
Because usually it works like this. Suppose you are entitled to MACP, correct? It works like this normally. Now, placement of first year, maybe 10 years of service, they are non-functional promotion. Non-functional means functional promotions is if it's given the rules itself. Functional promotion, the moment you complete 10 years, you get a promotion.
Yes.
You have some civil Meghalaya as functional promotion. Right. Now yours non-functional promotion will be also subject to fitness. So normally how these MACPs work is that after 10 years of completion of first 10 years, you get, one MACP, correct? And 20 years again, another MACP. And if you complete 30 years, then the third one of service, correct? It's like that. Now in your case, after completing 14 years, you got one.
Yes.
Correct?
Yes, Your Lordship.
Yes.
No, before I got the promotion, I already received the MACP.
Before the promotion, that means in 2008.
2010, if I'm not mistaken.
2010, you got one MACP already.
Yes, Your Lordship.
Okay, then you got regular promotion in
2012.
So how does it work against MACP? How does it work again? You already got regular promotion once.
Yes.
So whether you'll be eligible again for MACP unless it'll be another 20 years then. Is that correct? No, so shall I?
Going by the yes.
Because going by, he's already got regular promotion. After the MACP, he got regular promotion. Correct?
Lordship, yes.
Then how will they reconcile this MACP and his promotion? Your regular promotion only got once.
Only after he complete 20 years, then Lordship, in fact, so far that Lordship, the intention of the government is that if Lordship kindly come to para 23 at page 7 of the affidavit.
What does page 23 say?
Lordship, you say like this, I'll read only the relevant part, Your Lordship. It is stated herein that MACP shall be processed after the advance increment has been cancelled and regular.
You're not considered it as yet, but it's entitled or not right now.
It has
because if we dispose of the matter, that aspect is taken into consideration also. Okay, increments is one part, there's no recovery. Second part is regarding his entitlements to, he's already availed one MACP, but he's got regular promotion.
Yes.
And he served 10 years as a regular forester.
As a forester, Your Lordship, after promotion. Forester 1.
Because this MACP, how it works, I think it's just a placement in the next higher pay level. That's all. Yes. Okay, we'll not bother about that. Let's see the table. Okay. What's your pay level?
Now the full pay is
no level. Your level, yes. You're getting 2.8, how much?
Your Lordship is at para 71.
Is getting then an amount of.
I'm just trying to put it against this of the MACP table. But what that pay level is drawing? What pay level are you drawing? You have
Now is 51,480.
That is across total.
Gross.
That is across total.
Your scale.
Yes.
It commences from what was sir? Anyway, it get too complicated here.
Official pay is 35,700, Your Lordship. Then plus other benefits, it comes to cross total to 51,480. Then after deducting the GPF and then the NPS and all, Your Lordship, it comes to.
No, that won't be good. That wouldn't be. Yes. You come to page 58 of the petition. See clause 13. Where does he fit here?
Between level 10 and 11.
Because it's quite complicated. Then you have to apply FR 23 also. Because you already got one regular promotion also, yes. (10, 20, 30 years of calendar service). So what are you saying, yes, Mr. Shulai?
Lordship, because the intention of the government is very clear, Your Lordship. Once that increment was wrongly given to him, Your Lordship, is
no, come to draft rules. Whether you have intention of why you afford him?
Lordship, kindly, that was a mistake. Your Lordship, kindly come again to page 47.
Can it just be wished away as being a mistake?
Lordship, kindly come to page 47 at Annex 6, Your Lordship.
Yes.
Lordship, second paragraph, Your Lordship. Then somewhere in the middle, Your Lordship, a forester grade 1, 1, 2, 3, Your Lordship. In the middle, Your Lordship, a forester grade 1 who has passed the departmental training is deemed to have obtained a special qualification and therefore qualify for grant of 1 advance increment. So, Your Lordship, the intention of the government is that to an employee to be eligible for 1 increment should be the forester, and he should pass the departmental training, Your Lordship, not a forest guard, Your Lordship.
No, where's the one with referred to the rules?
Lordship, that is the same letter only from the beginning, Your Lordship. With reference to your letter quoted above, I am directed to say that the benefit of 1 admissible to the forester on successful completion of training in forest school as incorporated in the MS.
Then why does it say that is however considered as a guiding principle for smooth running and conduct of basic?
As incorporated in and still in operation as the government has allowed the system of advance increment to this is, Lordship, only specifically with regard to forester, Your Lordship, not with forest, not with forest guard, Your Lordship. Specifically with forester, Your Lordship.
No, Mr. Shulai, see, can you apply the draft rules only for smooth running, but you don't give the other components of the draft rules?
Lordship, only to the forester.
Read this one, see. With reference to the letter answered, I am to inform the Forest Guard School Media Training
Lordship,
Rule
yes.
13 is yet to be formally approved and notified by the government as it appeared, and therefore still in a draft form. Stop. Right. It is, however, considered as a guiding principle for smooth running conduct of basic forestry training of frontline staff, meaning foresters, forest guards, and malis. All 3 cadres it shows. So the guiding principle, and using the guiding principle, you gave him that honor certificate.
That was a mistake, Your Lordship,
You gave him 2 advance increments.
Because Your Lordship, that is why Your Lordship, the letter of 2002 has been issued to clarify the position, Your Lordship, that only the forester
letter of
16/9/2002, Your Lordship. As well as, Your Lordship, the letter dated March 2020, Your Lordship, which is enclosed at Annexure 15 to the writ petition. Lordship, kindly see towards the bottom, that Annexure 15 at page 65, Your Lordship. In case of a forest guard who have successfully completed the basic training course, 1 advance agreement may be granted. Here, Your Lordship, 2 increments had already been granted, Your Lordship, only on their promotion to the forester.
So why you cancel both advance increments then by the impugned order?
Lordship, that because what happened, Your Lordship, that increment was given to him, Your Lordship, in 2001, Your Lordship, in 2001.
Okay, comes impugned letter.
Lordship, yes. Lordship, that is at page 69.
Yes.
In modification of this order dated and as per government letter dated so and so, Shillong memo number so and so, 2 advance increment which was already granted arising from so and so is hereby cancelled. That's why, Your Lordship, I have referred to that letter 69.
The next sentence.
An annual increment is hereby granted to follow the pay scale of so and so. An annual increment is hereby granted as follows in the pay scale so and so. So, Your Lordship, after the cancellation, that means this should be the pay scale. Yes, pay scale.
Mr. There is no question of recovery. So, what do you have to say?
Lordship, so far,
Lordship stands that only that the 2 advance increments given to you were wrong by wrong implementation of the forest guards draft rules, which had not been approved.
Lordship,
so you have been enjoying since 2001. So they said we'll cancel it, and this is your new revised pay scale.
It is within the.
But there's no recovery.
Lordship, to that, if Lordship, I will rely on the judgment from the Honorable Orissa High Court, Your Lordship.
Let him finish his authorities. What authority? That's the only thing. And MECP, whatever as admissible, considering your years in service, you joined service 98.
Yes, Your Lordship.
Yeah, then they will factor that in.
Yes. But Your Lordship, I have some more citation to rely.
Yes?
I have some more citation to rely.
Yes, please.
Yes.
Take it out.
Your Lordship, if I take to this.
First one you said that was first citation was regarding draft rules. That if the government has the intention of implementing them, then it should be taken as they implemented. Correct?
Yes.
Is that what you're saying?
Yes, Your Lordship.
Where's that been? It's 2003.
2003.
Okay.
Volume 4.
Yes. Right. Draft rules.
Yes. Again, another one also is more or less the same on the draft.
The citation?
On the draft rules. That is of 2005 8 SEC 394. I am relying on para 23, 24 and 28.
Both SB Sinha judgment. 23?
23, 24 and 28. Yes.
The first own judgment.
Yes. Yeah, Your Lordship, if I'm allowed to read. As such, para 23, As such, it is been noticed by this court that in Abraham Jacob of Union of India and Bimal Kumari versus State of Haryana, such draft rules can be acted upon to meet the urgent situation, and no rules is operated.
No, but in this case, they said we're not. That is by mistake we applied the draft rules.
Yes, Your Lordship, but I have, after relying on this, I have another citation, which
yes.
It's
the same because by the same judge.
Yes.
Yes. Next one.
Another one is of the Apex Court. I have given one copy.
Yes.
In this case is also
which para?
Is para 13 to 15. Para 13 to 15. It's at page 10.
Yes.
Yes. They are allowed to read, Your Lordship.
Yeah.
In the state of Punjab and others versus Rafid Mashi.
This won't apply because there's no question of recovery from you. See, recovery is when you have to gauge the hardship caused to employee if recovery proceedings are allowed or disallowed.
Yes.
And where does the onus lie? Now this won't apply because they said no recovery.
But Your Lordship, by modifying the MECP or the increment which was given to me, is more or less like recovery the amount which was due to be paid to me, Your Lordship.
No, there's no question. Now, see, when wrong, not entitled, you are paid excess, correct? Okay, excess pay or whatever, for whatever reason. Now, in those situations where recovery is to be done, then the Supreme Court has laid down, a few, conditions.
Yes.
It's like that, like this in this Rafiq Masi case. And this case also, this is what case this? They followed the same principle. So if suppose your group C, your group D, your grade 3 or grade 4, then sometimes do not recover. Then retired employees or who about to retire, recovery. Now they say there's no recovery, they've made a statement.
But Your Lordship,
and recovery, suppose payment like in your case it's been made in excess of more than 5 years. So even in that case, recovery, sometimes the court will not allow recovery.
Yes. But I just want to meet here that see, this mistake was not committed by me.
Yes.
And I have nothing to representation or misrepresentation in this regard.
No, they have not said you have done any. There's no wrongdoing on your part.
Yes.
The wrongdoing is on their part.
Yes.
And in consideration of wrongdoing, they're not initiating the recovery proceedings for all those additional for the higher pay that you've drawn all these years. So this judgment won't cover your case. It's only regarding recovery. Yes. Next, the citation.
That's all.
That's all. Very good. Yes.
But Your Lordship, I would like to ask your consideration that if suppose if this is the case, if they have not recovered also, Your Lordship, it will hamper my service and as an retired servant, a government servant. Since if I have not, if directly is not recovered, but Your Lordship,
you see, you mean to say by recalibrating your pay scale,
yes.
The thing is that you're bring your calculation for your pension, that will have no consequence.
Yeah, but Your Lordship.
But the only thing is that MECP will have an effect. They'll calculate your MECP. Now you might get a pay upgradation after they consider whether you're eligible under the MECP scheme or not.
So,
and if you get upgradation in the pay in the post of forester grade 1, then naturally your pension, your last pay drawn will be recalibrated and you'll draw pension as per your last pay.
That's what Your Lordship. So I'm relying to this judgment that this mistake was not made by me.
No, that is
and plus by doing this, by reducing my salary, so it becomes that though it is not directly, but indirectly it have recovered from me. So it comes in that way because yes.
that the judgment is not sustainable. Yes, Mr. Shulai, what judgment you have?
There is a judgment from the Honorable Orissa High Court, Your Lordship. Because if the wrong is detected, Your Lordship, then the authority has the right to rectify.
That is a given.
Lordship, if Lordship kindly come to para 14 of that judgment. May I read it, Your Lordship? In view of the pleading available on record, if a mistake has been committed by the authority, it has got every right to rectify the same. In Rice Kumar so-and-so, the Apex Court so-and-so, held that it is not always necessary for the court to strike down an order merely because the order has been passed in breach of the principle of natural justice. The court
does not regard to pay scale or to pay.
Lordship. No, Lordship. This is what I would like to advise, Lordship, because a mistake has been committed. Then it was detected, and then we rectify it.
Take down. We'll make the order short.
Your Lordship, once again, I would like to place that as I have said before, suppose I'm getting 50.
I understand. Suppose you're drawing of 2,000, right? Your scale.
Yes.
Now, by virtue of that, you'll reduce to maybe 199.
Yes.
1950.
Yes.
50 rupees less.
Yes. So in that case, in the long run,
that argument is not sustainable. Yes. Take down here. The petitioner. The petitioner's case is that on the basis of draft rules, namely the, within inverted commas, the Forest Guard School of Meghalaya Training Rules 1994, stop the writ petitioner after completion of training as Forest Guard was awarded an honor certificate and Forest Minister's Prize.
Yes.
And within small figures, Forest Minister's Prize in the year 2001.
Thank you.
And consequent thereto, on 31st October 2001, was granted 2 increments with effect from 1st August 2001. Thereafter, the petitioner was promoted to the post of Forester 1, Forester 1, from the post of Forest Guard, on
Your Lordship,
21st June 2012. Yes.
Your Lordship, sorry to interrupt. If Your Lordship allow, I would like to get some more instruction with regards to modification in this regard.
What instruction? We'll dispose it off. Yes.
No, if this code allow us to.
We see, we just keep the matter pending as it is become open hearing again. After we heard the matter, See, that will not recover from you. The only thing is that they will factor in the MACP, and accordingly they have committed a wrong. They have made an affidavit that they're not following the draft rules, but the 2 advance outcomes were given. It's been corrected, but no recovery. There's actually no recovery, and so they've formulated a new pay scale for you. Like, no, we're just computing that, without the 2 advance increments, factoring that in.
Yes.
And now they will consider your MACP eligibility.
Yes. So, in that case, if your Lordship allow, let my senior.
Who? Your senior? Where? I don't see him. Where is he?
No, he's on leg in the other court. So let be in the end of the boat.
Sorry, Mr. Shakti.
Should have asked for time.
If you had some problem,
yes,
I'd ask you in the beginning, are you ready? He said ready. So we're not accepting that, Mr.
Petitioner was promoted to the post of forest guard and the post of forest guard on the 31st June.
Stop. It appears that thereafter, there appears that the respondents, on detecting that the 2 advance increments were afforded on account of what misunderstanding of application of the forest of those rules, on account of
a wrong application, Your Lordship. On account of the wrong committed, Your Lordship.
On account of the application of the rules which were yet to be formally notified. The 2 advance increments by the implement order dated
12 July
2022 were cancelled. Where is that order?
Lordship will find it at page 69.
69,
Your Lordship.
And the petition was granted a pay scale as indicated in the said impugned order dated 12 July 2022. The other aspect in the matter is with regard to the entitlement of the writ petitioner to upgradation of pay under the MACP scheme, which it has been contended will result in impacting his benefits which we derive in the computation of his pension. Next paragraph. The pension. So, being aggrieved with the cancellation of the increments and the impact the same which would have on the his pensionary benefits as is due to retire on
November
October 2023. The incident, hence the incident was filed. Stop. Next paragraph. Mr. P. Shatil, counsel for the petitioner, has submitted that the 2 advance increments were allowed to the petitioner by the respondents by the application of the rules, forest guard so and so 2994, which the respondents had been following, as evidenced by their communication by letter dated 16 September 2002 No, not that, that's not the letter, sorry. A letter. A letter dated March, how much? 19 March 2020, bracket next year 15. Wherein the respondents have indicated that the training rules were considered the guiding principle for smooth running and conduct of basic policy training. So, he submits that the respondents are therefore stopped from cancelling the increments which had been granted by following the said rules. So, it has also been submitted by the counsel that the petitioner, now having served for over 10 years on being promoted to the post of Forester 1, is also due for consideration under the MACP scheme. It has not been done as yet, which is yet to be.
Because it has to be re-regulated, Your Lordship.
Processed by the respondents. So, what other submission you have in support of his arguments with regard to the application of draft service rules? The council has placed reliance on the judgment, the case of so-and-so, reported in 2003, 4 SEC 712, and the case of so-and-so reported in 2005, 8 SEC 394. He concludes submissions. He then concludes by submitting that the action of the respondents,
Sorry, Your Lordship.
which is not, the other is not important because it will not apply, no recovery is there. If the recovery, after the recovery is there, or you mentioned it. Yes, Thomna?
Concludes a submission that the action of the respondents.
He concludes by submitting that the action of the respondents is arbitrary and illegal, in as much as no wrongdoing or misrepresentation can be attributed to the petitioner in the grant of the 2 increments, and that with the cancellation the petitioner has been unjustly deprived of the pay scale he was enjoying for how many years enjoying till the said cancellation stop. He therefore prays that the impugned letter dated 12 July 2022 be set aside and quashed, and the respondent directed to process his MACP as expeditiously as possible. Yes. Next, Mr. Indi Shulai, letter EAG, assisted by so-and-so, has at the outset submitted that the grant of the 2 advance increments was on a wrong premise, premise, comma, in as much as, comma, the Forest Guards School of Meghalaya training rules was yet to be formally approved and notified by the state respondents. Stop. It is further submitted that it is first submitted that in the case of forest guards who have successfully completed their basic training, one advance increment can be granted only on their promotion to the post of Forester Grade 1. He submits that as the writ petitioner was yet to be promoted at the time of the grant or on increments, no entitlement. Sorry. Which is with the same sentences now? At the time of grant? Yes. The same on being detected by the respondents was therefore sought to be corrected by issuance of the impugned letter. No doubt, after the writ petition enjoyed the same for 20 years.
Yes, Your Lordship.
Not 20 years, 2001? 10 years.
More than 20 years.
For over 20 years. However, he has categorically submitted that no recovery is sought. However, he submits that there will be no recovery of any amounts alleged to have been there will be no recovery of the payments that have been made to the writ petitioner, and that the impugned order has only cancelled the said entitlement. The learned AAG has referred to, where's that first letter? That referred to a communication dated 16 September 2002, bracket annexure 6, to support to another 6, wherein is indicated that under the existing rules, orders, advance increments are allowed to government employees for possessing higher or specialized qualifications than the prescribed minimum qualifications. And as such, a Forester Grade 1 will be entitled to such advance increment as he has obtained a special qualification. Stop. He also submits that Where the letter? He has also referred to, the learned counsel has also referred to the learned counsel on this point has also referred to a letter dated 19 March, the communication letter, 19 March 2020. Wherein he submits has been indicated that no extra increment shall be granted to any staff on the ground that he or she has successfully completed the training course. He contends that the advance increments which were granted to the writ petitioner, therefore, not being as per the prevalent rules or executive instructions, the action of the respondents in cancelling the same cannot be said to be arbitrary. With regard to the entitlement of the petitioner under the MACP scheme, it is submitted that the same shall be considered in accordance with the consider taking into account the service, the total number of years, the years of service rendered by the petitioner, along with entitlement to the same. Stop. Having heard legal counsel of the petitioners or for the parties and examiner of appeals and record, it is seen that the respondents had granted the advance increments to the writ petitioner by adopting the stipulations given in the, what rules are that? Forest guards, so and so rules. Where are the rules? Oh yeah. Training rules. Where is that? Where
Page
you say?
19.
Yes, where do you say that? Where?
Page 26.
Where? Huh?
It is seen that the respondents had granted the advance increments to the writ petitioner by adopting the stipulations given in the
Wherein at Rule 16(3), the same has been provided for. Stop. However, the cancellation which has been resorted to by the respondents is on the basis that the said rules are yet to be formally approved and notified, and the same is only in draft form, and the application of the same in the case of the petitioner was on a misunderstanding of the same. Stop. It is further noted by this court also, it's further noticed that as per the prevalent instructions, an advance increment also can be granted only on the promotion of the forest guard to the post of Forester Grade 1, and that further no extra increment is permissible on completion of training with honors, with training or with training with honors, or on receipt of an honor certificate, you said, no? Yes, Mr. Shati?
Yes, Your Lordship.
Honor certificate. Stop. Next paragraph. Last sentence, Amma.
It is further noticed that as per the prevalent instructions, an advance increment also can be granted only on the promotion of the forest guard to the post of Forester Grade 1,
yes.
and that further no extra increment is permissible on completion of training with honors or on receipt of honor certificate.
Yes. Stop. Next paragraph. It is, you don't brought a decision on that part, and you did that. There are some decisions, but I don't have it ready with me. It is settled law that on the detection of any extra payments which were made in view of misinterpretation or miscalculation, the employer or the state respondents are well within the rights to correct the same. Stop. In instant case, what is clearly apparent is that the rules, the rules are yet to be approved or formally notified, and as such, the grant of the advance increments cannot be said to be on the cannot be said to be as per any prevalent rule or executive instructions. As much as from the records it is revealed that no advance increments are admissible to forest guards, and it's only on promotion thereof that the same is accorded. Stop. The question of recovery, which normally arises in such matters, however, as categorically submitted by the learned EAG and as evidenced by the impugned letter, has not been contemplated by the respondents, and as such, in this regard, no injustice is what can be said to have been meted out to the petitioner. Stop. Next paragraph. As far as the entitlement of the petitioner to the benefits under the MACP scheme, the state respondents at the learned EAG, as also the affidavit filed by the respondents, has recorded that the process for granting MACPS in respect of the petitioner has not yet been completed. And the same, the process has not completed.
As far as the entitlement of the petitioner to the benefits under the MACP scheme, the learned EAG has also the affidavit by on behalf of the state respondent has reported that the process for granting MACPS in respect of the petitioner has not yet been completed and the same.
Yes, as the advance increments granted to him from 2001 have to be rationalized and regulated. Stop. Next paragraph. In this view of the matter, as there is no recovery sought to be made by the respondents, and as the advance increments had been granted on a mistaken interpretation of the prevailing rules, the action of the respondents can be said to be arbitrary, and no injustice can be said to have been caused to the writ petitioner. Accordingly, the petition stands in view of observations made in above, and for the discussions made in above, is closed and disposed of. Yes.
Lordship will kindly make an observation. The interim order partially will stand merged with this judgment.
What interim order?
Lordship, that has been stayed, Your Lordship.
Recovery?
No, Your Lordship, that impugned order of July 2022, that has been stayed by Your Lordship.
All interim orders pass only as stand vacated.
Highly obliged, Your Lordship.
List, item 32.
What specific, you supposed to come with specific instructions today?
Your Lordship, as per the order dated 17/3/2023, I was been asked to
17/3.
Yes, 17/3/2023. I've been asked to produce this
instructions, and the instruction is with me, Your Lordship. Oh, this.
1 second. 24/7. 24/7/2023.
As per order dated 17/3/2023.
24/7. See 24/7/2023. Mr. Ibrahim Al-GA director obtains specific instructions on the terms of engagement and entitlement for petitioners.
Yes, Your Lordship. I got the instruction, Your Lordship.
What did they say? Are they still working?
No, no more, Your Lordship. We have.
Lord, that is the dispute, Lordship. Now.
What dispute?
Now the item number 23, Lordship. When the order was passed in
23,
because item number 23 and 30 are connected, Lordship. So item number 30 is with regard to the revision of pay, Lordship. Because all throughout I was
23 Roman Sangma.
20.
What item?
That Emmanuel Lamare, Lordship. Yes, Lordship. Yes.
That is item 32.
32 and 40, Lordship. Sorry. 40, Lordship.
32 is what? 32 is stopping of pay.
Yes, Lordship.
And
pay.
40 is?
40 is revision of pay, Lordship. The first writ petition was filed, the item number 42, Lordship.
40 is or same money?
Yes, Lordship.
Right.
40 is with regard to the revision of pay. Because all throughout I have been receiving the benefits of the revision of pay. The benefit of last pay revision, I was not given. They are not saying that I am not entitled. The dispute is saying that it is the home guards that the petitioners where they deployed. The authority is saying that it is the home guards is to calculate the pay as per the revision.
Item 40.
Yes, Lordship.
Home guards calculate your pay.
Yes, Lordship.
Your pay revision.
Yes, Lordship. Unless the home guards calculate the salary as per the revised pay scale, we cannot pay the salary at the rate of revised pay scale. That is the contention of the requisition.
Unless the home guards approve that.
Not approve. Okay. Make the salary as per the revised pay. So we cannot pay.
Who said?
That is the requisition authority.
The requiring department.
Yes, Lordship.
Then?
Now the same authority is saying, writing a letter to the home guards, saying that no, with regard to the revision of pay, it is you have to put up the matter.
What?
The requiring authority, Lordship. The requisition authority, that is the PSC, written a letter to the home guards, saying that no, the matter with regard to the revised pay scale have to be initiated from your side. So now they are not saying that I am not entitled. Only the issue is that who is to calculate my revision of pay. When the matter was heard, then 17/3 to 20 of this year, Lordship, the state was directed to get the instruction. Then after that he obtained few dates, Lordship, with regard to the instruction. Then in between my salary was stopped. Then I put up an application asking for salary. They are not paying. They are saying that they have not said anything. Only they have issued a letter saying that no, we cannot pay the salary. Then, Lordship, I have apprised this court, and this court has given some direction. The pendants of the writ petition shall not be a bar.
No. Another thing is that this 23 and the order dated 24/7. Have you brought now? What instructions do you have? Let's see. See the instruction. What instructions do you have? You don't have to remove a copy. Just show instructions you have.
The 11th para will be the next second page, Your Lordship. The last second para, Your Lordship. Even please to read, Your Lordship. As per 3.1 of the term and condition for engagement of home guards, volunteers with requisitioning agency, the Home Guard volunteers are entitled the duty allowance, which shall not be less than the duty allowance minimum wage prescribed by the government, Annexure 4. The current rate of duty allowance of the Home Guard volunteers is rupees 439 per day, with effect from 1st April 2019. White government letter number such and such. Annexure.
You're asking for 5th pay commission?
Yes, they want a 5th pay
in
commission.
item number 40, Lordship.
Then it may be further mentioned that the state government, while examining the applicability of the 5th pay commission to the Home Guard volunteers deployed with the State Forest Department, stated that since the nature of the service is voluntary, and also since the Honorable Supreme Court in its latest order has rejected the petition of the Home Guard volunteers in the state of Himachal Pradesh, Punjab and Delhi for regularization of the service. Therefore, the recommendation of the 5th pay commission does not apply to them. By this, it is understood that the Home Guard volunteers deployed with any agency being voluntary do not fall under the purview of the 5th pay commission. This has been given by Joint Deputy Commandant General of Home Guards. So they are not entitled for 5th pay commission. 5th pay commission is entitled only to those government servants who are working at sanctioned post.
The thing is that what do you pay? You paid a scale before?
That is my appointment order is very clear, Lordship.
Now they're saying entitled 439 rupees per day.
No, my lord, my friend has not.
Has not what?
Because that there is a recent judgment, Lordship. What my friend is saying, Lordship, that is 23 of this year, 23. The Supreme Court has passed judgment. But here also that recommendation of the, they have given the direction to implement the recommendation that benefits of the pay commission. I'll come to that, Lordship.
One second. Because they paid under the Meghalaya ROP rules.
Yes, Lordship, yes.
You put an affidavit. When can you file it? You have the instruction, you put an affidavit, you give him a chance to you have to give him a chance to rebut this.
Because this year,
because now you're saying that, okay, but usually the responsibility of paying the Home Guards with the requisitioning department agency, correct? They are to pay.
Yes,
but who fixes the scale of pay?
That is, the requisitioning authority is saying that in the affidavit which they have filed by the requisitioning authority, saying that it is the Home Guard. Because earlier, it is the Home Guard has fixed the...
Now, in your appointment order, the scale of pay which you allowed was fixed by the Home Guard?
No, yes, Lordship. Yes.
Is that correct, Mr.
Yes, Lordship.
That's
now the thing, they fix the scale of pay, then the requisitioning agency pays that scale.
Yes, Your Lordship. That's what...
now you say that is not applicable anymore.
My Lord, in order to clarify that issue, Lordship, kindly come to my appointment order, Lordship. That is at type copy is at page 13A, Lordship.
13?
13A. Annexure 1, Lordship.
Okay.
In the interest of the public service, the following trained Home Guards volunteers who are temporarily appointed as guardsmen with effect from so-and-so in the pay scale of so-and-so, plus other allowances admissible under the Meghalaya Service Revision of Pay Rules, 1980. Now, Lordship, next Lordship, that annexure, next Lordship, annexure 2, Lordship, that is the benefit of the revision of pay.
99.
Yes, Lordship.
Okay.
Now, in the counter, Lordship, in the item number 40, if my Lordship kindly come to page 17, this is the counter which they have filed in item number 40, Lordship.
Yes.
Page 17, para 7.
Yeah.
With regard to the abatement made it at para 4 of the, so the depot answer is there, the annexure 3 that which I have relied just now, Lordship, that 99, that revision of pay, was not issued by the office of the respondent number 4, but in fact it is the office of the respondent number 5, that is the Home Guards, who was issued the same, and the copy of was given to the respondent number 4. As respondent number 4 is just the paying authority, and whatever the funds have been allotted on behalf of the respondent 1 to 4, the respondent number 4 has released to them. It is pertinent to mention out here that whenever there is a revised pay of the petitioner, it is the respondent 5 who have issued an official order communicating the respondent number 4, as it is evident as per the Annexure 3 of the writ petition, that which I have relied, Lordship. As such, the revised pay of the petitioner has not been raised after the year 2016, as there is no official order from the office of the respondent number 5 for revising the pay of the petitioner. Now, Lordship, now what is the response from the requisition authority, Lordship? Kindly, Lordship. Page 29, Lordship. They have annexed the letter in their counter, Lordship. This is from Home Guards to the requisition authority, Lordship, PSC department. Subject revised pay, yes, sir. I'm just reading, Lordship.
Page 29.
29. In inviting a reference.
I'm on page 29.
In the item number 20. In inviting a reference to the subject cited above, I have the honor to inform you that deployment of Home Guards volunteers with your agency is on temporary basis. It may also be mentioned that pay and allowances for the Home Guards volunteers are drawn from your budget provision. In this connection, I would like to inform you that the revision of pay of Home Guards can be taken up from your side. I am also enclosing the herewith the terms and conditions for your reference. Now, the respondent number 5 saying that it is you have to initiate, and the respondent number 4 saying that it is you have to initiate.
Now it is new development.
Now
they hold that ROP is all gone. They say you're entitled to fifth pay commission, you're entitled to pay revision, you're entitled to daily wage 439.
Now, Lordship, that with regard to that, I have recent judgment, Lordship.
So what are you going to do now?
I have recent judgment, Lordship. That is this year's judgment, Lordship. That matter was travelled up to Supreme Court, Lordship.
Yes.
In 2016, the matter was heard. Then some Home Guards from different states, they went to the Supreme Court. They were seeking regularization. But so far as the regularization of the Home Guards is concerned, the Supreme Court has turned down. But with regard to the other benefits,
well, judgment. But you have to rebut this. You take this back. You file the form of.
I'll do that by way of.
Then the order was not clear. Then again they filed contempt, and in the contempt, my Lordship, the order was clarified. Then relying on this judgment of 2016, some of the Home Guards from the Odisha, Lordship, they approached to the High Court. The High Court, relying on the judgment, they given the benefits. Then matter again went to Supreme Court.
No, you mean to say that after being paid a regular pay scale, you can't be reverted to fixed salary? Is that your case now? They have to change now. If once they file affidavit, because in the instructions it says that you're not entitled to ROP, you're not entitled to fifth pay commission. You are appointed. You allowed a regular pay scale, correct?
Yes.
Well, an ROP was given 2016, or
yes.
Whatever it was revised.
Yes.
Now you're going to be paid a fixed pay scale, as per your instruction, correct?
That
right.
The benefit should be
you filed an affidavit, yes. Mr. H. Abraham, today has produced written instructions indicating the payment permissible to the Home Guards. Peruse the same. Learned Counsel, Learned Counsel directed to place the same by way of an affidavit to enable the petitioner to file the rejoinder. Yes. Just after 3 weeks or 2 weeks enough. List after 2 weeks.
Then item number 40 also same.
Together item 40. See, the thing is that the only thing is now whether what kind of service will be called. We put them in the pay scale. Now you say that if some judgment is there, they will revert back to fixed pay. They'll lose.
Now this High Court has already passed order that Gulab Sena I have put up that judgment also.
I think this
same issue has been raised, Lordship.
Other these matters become infractions because we have already disengaged them since January of this year.
Lordship, disengaged by the requisition authority. I have to go by the that Home Guards Act 1947. Lordship.
Yes, voluntary.
Yes, Home Guards Act. Whether they can disengaging would be discharging from service.
Yes.
Seven.
Yes, from Thao, Dr. Mozika.
So I appeal for the petition.
School matter.
1 to 4 years. I think this the private respondent Qureshi will
Managing committee.
Mr. Paul is there. Yes, Mr. Paul.
I stand engaged to represent the management of the school. Now, what has happened is, on the last occasion, some miscellaneous application has been filed in the writ petition, and your lordships have passed an order, on 15/9/2023, staying a recruitment process that was initiated by the respondents.
Yes. Yes.
Now, I just wanted to point out one small issue, if your lordship kindly have the writ petition.
Yes.
The writ petition actually challenges the constitution of a certain mapping committee.
Right. No, the only consideration why the court had passed that order was that the managing committee which is in place is expiring in a few weeks or something like that.
Next month, Lordship.
Next month.
31st October.
Next month.
Yes. Who's appearing? Who filed a miscase? You filed a miscase.
I prefer a miscase.
Yes. Yes.
What I am submitting before your lordships as well is that this was a regular process. It is not something that happened out of the blue. The posts were vacant, they were advertised, and they would be filled up in due course. Now, the only issue, what I should point out before your lordships is that even though the main challenge in the writ petition is with regard to the constitution of a certain managing committee, the miscellaneous application which has been preferred before your lordships, there is this prayer for keeping.
You are newly engaged now here, Mr. Paul. You're newly engaged.
It seems.
I am newly engaged in this matter.
Since when? Because 15 is just last Friday.
Last Friday, Lordship.
Mr. Qureshi was Mr. Qureshi.
Mr. Qureshi was appearing earlier. Now, the fact of the matter remains, that this prayer in the miscellaneous application is not ancillary to the main prayer in the writ petition.
I read you with the matter today.
If your lordship is so pleased to hear us.
Will you dispose of the entire case?
The entire matter can be heard and disposed of.
Yes.
Lordship, then if it can come on Monday, Lordship.
Why?
The senior leading the matters. Just.
It'll happen on Monday. Next week.
Monday, very well.
After, yes, next week.
Monday there's a division bench matter. Division bench matter.
Okay, Tuesday. Next week.
Your Lordship, even Easter Tuesday, it could be like Wednesday, Your Lordship. I have some personal difficulties on Tuesday.
It'll happen on Sunday then. It'll all be free.
Lordship,
Your Lordship,
we could have
they have been appointed on our behalf.
Okay, just record that Mr. K. Paul, Legal Senior Counsel, has been engaged on behalf of respondents 5 to 7. Submits that in the matter the matter be heard on
Wednesday, Your Lordship, if subject to the convenience of Your Lordship.
Matter may be heard today. Stop. However, Mr. H. Abraham, other counsels pray that the same be taken up next week. Yes, list on Wednesday. Then.
Should the interim order, perhaps? Interim order.
Any interim order can continue till the next day. Yes.
Hello,
41.
The support appearing the next item 38 also for respondent. He left. Yes. Doesn't matter.
38, we are still there, Your Honor. Your Lordship.
Very well. 38 what? Yes.
38, was it called?
38 we listed together. This is item 41, yes.
41.
That please, Your Lordship. Lordship, this is a McCoffin matter, my lord. We are before this honourable court for gratuity and leave encashment, my lord.
But you're not there in the earlier litigation, correct?
Lordship?
You're never around in earlier litigation. You're not involved at all. Where's Mr. Yubin?
Lordship, that is where I am coming, my lord. Similar situated person who had not approached the court, my lord, they also given the benefit of gratuity and leave encashment, my lord. And that is the reason why, my lord, some of the
Wait, let the concerned counsel come. Absolutely.